Yes, just before you start, the parties are, I think, owed an apology over the confusion about the filing of the bundles. We've made some investigations, and it's clear that the fault was not with the parties, but was within the court office. So you have the court's apology for that and for the fact that it led to it being put back by a day.
I'm grateful, my lord. I take no issue. My lord, I appear on behalf of the appellant, my learned juniors, of Mr. Lowe and Mr. Jeremy to my left.
Yes.
And for the respondent is Mr. Miller, King's Counsel, and Mr. Gallop. My lord, you should have before you the core bundle, a revised supplemental bundle, and an updated supplemental skeleton argument from us. So akin to a speaking note, really, just emphasising what my Lord Justice Warby queried. My lord, there was this morning, and I apologise, it became clear to me that the transcript of what happened below became somewhat relevant. That's my fault. I realised in preparation last night that actually, having revised my preparation, that document was not before the court. These expedited hearings somewhat, the preparation time is not always the best.
No, right. Well, if Mr. Miller wants to object to our being shown any of that, he'll say so when the time comes.
I'm grateful. My lord, to simply say this, both Mr. Miller and I are in the court below, so the transcript, we say, doesn't cause any prejudice. My lord, I was going to start with that, if I may, after, if I can ask you, please, if you go to the supplemental bundle index.
The first supplemental bundle.
Yeah, the revised, I think it's called revised.
Yes.
Not the further. And my lord, by way of introduction to your lordships, if I can ask you please to turn to page 8. I think we made it quite clear in terms of the chronology. So if I do this somewhat swiftly, my lord, you'll be aware that this is the order dated the 16th of January. And my lords, if you see paragraph A, her ladyship considered point A and B. The claimant's striker application filed on 31st December, and the claimant's application to join 6 new defendants and to re-amend the particulars of claimant B. You will see this is the second order where we had sought to argue before her ladyship the issue of the amendment of the Joinder application. We made an application before that date, and you'll see at page 10 specifically under paragraph D,
yes.
5 lines down, in relation to our application for the second time. They've already had a previous order. I'm not prepared to list the application for determination at the pre-trial review. First, in fairness to all parties, it's too late for such a substantial application to be added. If you go perhaps 5 lines from the bottom of that paragraph, the issue as to whether they are entitled to be served with the application to make representations will need to be determined before the application can be determined. You'll see, I can see no justification for the Joinder application. My lords, it is on that basis that we approached the pre-trial review that the application was refused, and we prepared for the pre-trial review on the basis of that application would not be considered. It was simply to be set down for directions. We drafted some directions previously, which was, I say neutrally, in terms of the dates we proposed. We did our best. We thought that the application could be heard, or would be, or should be heard, with the application to strike out, etc. My lord, if I may ask you, do you have hard copies of the transcript from the court below, please? If I can point out, this is where we say...
I have it on screen.
That should be fine.
Not a hard copy.
Would you like a hard copy, my lord?
I'm happy to use it on screen.
We do have one. We do have a hard copy if you'd like a hard copy, in case you want to mark it up.
Very well.
Does your lordship have a hard copy?
Yes, we've
We've got hard
do.
copies, but you can mark them up on screen, or I can anyway.
You're ahead of me. I don't have that ability.
Yes, which page would you like us to go to?
My lords, can I ask you please? My lord, there's internal page numbers. When I say the internal page numbers, I'm talking about the smaller number. You will see, if I could do it by way of introduction, that the primary consideration at the beginning was whether there was to be the other parties to be heard at the appeal. Sorry, excuse me, at the hearing, at the application, the proposed defendants. My lord, if I can ask you please then to go to page 7, which is bottom of page 25. I apologise, it's in four parts per page. There's a discussion between my learned friend Mr. Miller. You will see if the hearing is to go ahead on Wednesday. So there's a discussion about when applications are going to be heard at page 25. So you can see what Mr. Miller is saying. You can read that for yourself. And if you could see over page 26 in the top right-hand corner, what we're saying there, that's myself. Sorry, my lady, was just talking to Mr. Jeremy on this point. Our application went in on the 31st of December. If you could just pause there, the point is this: is that the suggested, the re-amended particulars of claim was sent on the 23rd of December, along with the letters asking for the defendant in the usual way. Will you consent to our application to amend? So they had the 14 days from December. It wasn't processed until the 8th of January. That doesn't matter too much at this moment. But, my lord, if you will see, then, if you will...
What do you mean by it wasn't? Sorry, what do you mean by it wasn't processed by the court?
Yes, I don't think it was processed till the 8th of January in terms of the formal application. Forgive me. So the letter went on the 31st. They didn't agree to the amendment of the pleadings, which was no surprise, and so then it was processed and it was received by the court on the 8th. I think it was a few days earlier that it was sent in. My lord, if I can take you to the point I'm going to make, internal page 9, which is page 33. And what you will see there, Mr. Miller, my learned friend, goes into at the bottom of page 33, in relation to the service of the application. I'm pausing there. We know that the defendants had the re-amended particulars of claim on the 15th of December. We suspect earlier, but we can't confirm that at this stage. That will become relevant to my submission shortly. But you will see then Mr. Miller starts to make reference to the application, the merits of the application, if you go over to page 34 and then down to 35. And her ladyship clearly sets out, I'm just wondering whether you, so page 35, I'm just wondering whether you're going into the substance of the application to amend now, which I am not dealing with at this stage. The question is when it should be dealt with. My lords, if you can then please go over the page to page 10, you'll see page 39. What I say at that point is, my lady, you have made the directions my learned friend sends. We have arguments against all of those points, and the merits of that application have not been heard. The reason I've said there was no application on Wednesday to vary those directions, there was no application to vary those directions, so we were stuck quite properly with the fact that the application to amend was not going to be dealt with. That was the point I was making. And then at that stage, then Mr. Glenn, who's not here today, for one of the prospective defendants, starts to make the point over the page again, at page 11, please, internal page 41. And again, the date's the 23rd of December at point 10. You'll see Mr. Lewis himself until the 23rd of December, so 10 weeks from the trial and just before Christmas. We say in those circumstances, the notion that the claimant will discharge what is often referred to as very heavy burden facing applicants of this nature is something which should not be indulged. As Mr. Miller has pointed out, it is quite unclear what the unlawful means conspiracy claim would add to the claim already on the record beyond causing additional disruption and distress. I'll come back to that point shortly. And then you will see what Mr. Helm says also for one of the other defendants or proposed defendants. He then says at page 43, internal page 43 at 14, I agree with Mr. Miller and Mr. Glenn that the most appropriate course is that the court does not need to make any directions today. So we had approached the hearing for the avoidance of doubt on the basis we were going to get directions for the application to be heard the week after or the week after that. That's how we'd approached it. I mean, my lords, if you then please, you see where we say that the judge started to go wrong. Page 46, which is page 12, the top right-hand corner, please. I can see on the face of it, you will see what I say. It is the court's general powers of management, my lady. I pause there. You have not heard the substantial application or the merit which we say is high in relation to the amendments which impact upon the defendants. I do not say proposed defendants, they will be defendants. And this is what I say, and I say I'm right. At the bottom of that, I say that application, my lady, going into page 47, does impact on the trial. We do not want the trial to be vacated, but because of the behaviour of the defendants and the delays, there may be no choice. My client wants this matter dealt with, but he wants it to be dealt with fairly. The perversity of the situation is if this trial, if this was heard after the trial, potentially, my lady, potentially is that we would have two judges coming to two different findings of fact and two different findings on credibility potentially. They are so interchangeably linked, it is not possible to divorce. My lady, much of this will turn in my submission on the application next week. I urge your ladyship not to direct this is heard after the trial, because notwithstanding what the defendants and the proposed defendants say, no merits have been heard, or any explanation given to the court as what they say is the delay. We say not our fault. And again, she hadn't heard my submissions in relation to the chronology. My primary position at direction should we consider after the application next week. If you could turn over the page, my lordships, please, to internal page 49. You will see 4 lines down. This is an amendment. I accept the amendment is significant. I do not shy away from that. But our primary position is that we would benefit like this heard before trial. It is to everybody's benefit. If the application fails, it makes no difference. The trial goes ahead. If it succeeds, in the interest of justice, I think the reality is we have to face the trial may well get vacated. That's the position of all parties. My lord, at the bottom of the page, we say, there's no reason we say that the application couldn't be heard within the next 2 weeks. That was my position then, that's my position now. There is no reason in my submission, because again, the pressure is upon us to serve the documents which my learned friends seek. There is no resistance in relation to the serving of those documents for the reason I dealt with previously earlier this morning. It is our primary submission that direction should be given today so this can be heard before the trial for everybody's benefit. And I emphasise, again, I say I'm right at this stage. At the top of the page 50, I said that my primary position, there's no reason why an application, my lady, it is an application, it is not the trial, a freestanding application which is often dealt with by the courts within a few weeks. If you could turn over the page, my lord, please. And I set out, again, as I say, as night follows day, levelling the criticism at this side of the room for the late application is not fair, but the application be made, and that needs to be considered on its merits before the trial date. Otherwise, my lady, without you hearing more arguments I can go through, it would probably take me several hours to go through the minutiae of that. I just pause there, my lord. My position there is that on the basis of us having been faced with 2 court orders, it will not be dealt with on this day. We have not prepared the bundle in relation to the application to amend. Obviously, it would have been subtly but importantly different with different documentation before her ladyship. But
I don't really understand that. You made the application in January. What was to stop you putting forward all the evidence that you wanted to rely on in support of the application at that stage?
Because her ladyship had ordered that the application would not be heard at the pre-trial review, so the pre-trial review bundle was slightly different.
No, but she hadn't made any order. At the time that you made the application, she made no order at all.
She made an order on the 16th of January, my lord, to say that the application would not be heard at this pre-trial review. I'm sorry.
No, my question was about the early January, before the judge made any order, before she knew anything about this application. You made the application.
Yes.
You have the opportunity to file evidence in support. You do file evidence in support. What was to stop you putting in evidence at that stage of everything that you wish to rely on in support of the application to amend, including delay and whatever else you thought was relevant to the merits of the application?
Yes, I apologise, my lord. You are right. We did, when we made the application, there was a witness statement, a lengthy witness statement, setting out. My point is, in terms of some of the evidence and some of the correspondence which would have supported the application was not in the pre-trial.
Yes,
that was my point. I'm sorry.
What was Mr. Clarke's third witness statement in the bundle?
I'm sorry.
Was Mr. Clarke's third witness statement in which he addresses delay in the bundle?
I know his 4th witness statement. Excuse me. I believe it was, my lord.
Yes. And that's where delay is addressed.
That's where delay is addressed, but I'm going to just assist you with that shortly, if I may, please. My lords, in relation to, if I can ask you please to turn to page 14, because this is quite important. If you look to page 54, again, what we say is, at that stage, on the 20th of January, we say, notwithstanding the faulty disclosure, it's point 7, notwithstanding the faulty disclosure, we had recordings withheld, we had the redactions which did not make sense. Just pausing there. That was quite important because we still to this day, there's recordings on which have been transcribed, which we don't have. They simply won't give them to us. Down the page, I then touch upon, page 55, notwithstanding the 19.49 provision, which we have touched upon, on the locus point, we are essentially in the court's hands. At the moment, we're in a rather peculiar position where the merits of the facts, i.e. the application, has not been determined. If you again just turn over the page, please, to page 15, and it's page 57. This will come back to the substantive point shortly, which I'll address. Page 57, you will see point 14 again. I'm addressing her ladyship. My lady, the facts of this case in relation to the proposed defendants, some of them are witnesses in the trial. Your lordships no doubt would have picked up on the point that in relation to this trial, which is to be heard, 3 of the defendants in the re-amended particulars of claim are not witnesses. So we have 3 defendants which are not part of the libel claim, if I can put it like that, but who are defendants in the amended claim. So we don't have them at trial at all, and they don't have any questions to be answered because they're not witnesses are so linked that we would be in a position we'd be operating in a vacuum where the amended case and primary case, which is now in accordance with the amendments, would not be able to put to those witnesses, i.e. the defendants. It is not just about credibility, it goes to conspiracy. And over the page, you will see there Mr. Jeremy addresses the ladyship. And what Mr. Jeremy says, quite rightly, what he says at page 62, top right-hand corner, point 4. First, there is the matter of the hostile journalistic sources who we say are the conspiracy, within the conspiracy.
I'm so sorry, I've lost you. Where are you?
So, I do apologise, my lord. Page 16, internal, and it's page 62 at the top right-hand corner. What Mr. Jeremy says, quite rightly, first, there is the matter of the hostile journalistic sources who we say are within the conspiracy committed crimes. They are not witnesses in the trial. They are not witnesses on behalf of the defendant. They are the ones we say in the amended pleadings directly participated and procured the material on which the defendant ultimately published defamatory matters. And this is where the ladyship starts to go wrong, in my respectful submission. Those are matters, point 21, those are matters that can be put to the defendant's witnesses, are they not? If you are saying the defendant did not contact complainants on matters that kind, those are precisely the kind of words that you can put to the defendant's witnesses. Mr. Jeremy then addresses it. He said the court cannot properly understand the background to the falsity that goes to the heart of the truth defence came about, namely through an unlawful means conspiracy. My lord, if you could turn over the page, please, and this is where we say there are some clear errors. I congratulate Mr. Jeremy at page 64, point 21, he articulated it better than I was at that time. Mr. Miller then at page 66, you'll see at point 15, it is not accepted there's been any failure of disclosure. My lord, we now know that is not correct, because after this hearing, in fact, we had some documents just before the hearing, this hearing, crucial documents, and more important documents even after this hearing because of the inadequacy of the disclosure. But just pausing there, we say this is wrong because Mr. Miller says this. There were some extensions of time from August for the disclosure to begin, but 99% of the disclosure was given on that date. It is incorrect to say there were more substantial tranches of disclosure given after that. Well, that's just wrong. We had substantial disclosure after the 3rd of October. Again, we'll touch upon that just in a moment. And then what Mr. Miller says, it is very commonly seen in pleadings in the High Court at point 9, page 67, that a party would plead either way, whether an original pleading or the amendment. And he says at 14, a pleader will say, frankly, we admit there are certain things we cannot plead at the moment, but we believe there will be things we can plead after the disclosure is complete. Well, again, I say, when I refer to the authority in a moment, some of it may be trite, but I say this is where her ladyship starts to get confused. If you turn over the page to internal page 68, we emphasise the point. Mr. Miller emphasises the point at page 68. Halfway down, point 9. If there were findings of fact in March, in the March trial on the truth and defamatory meaning, and whether this is a lawful public interest to settle publications by the Guardian, any attempt in the later trial as between the claimant and the Guardian, we say, as between the claimant and the Guardian and Mr. Lewis, the proposed second defendant, any attempt to try to reopen those findings of fact and law would fail because they would be res judicata. So we don't have the defendants there, we don't have the witnesses there, but yet we're supposed to put our case, and even if the amendments after the trial were allowed, the issue of res judicata would be raised. That's what Mr. Miller says. But more importantly, insofar as the other defendants were then added to the pleading, if that was the outcome, it would be an obvious abuse of process. Mr. Miller may be right. that means we can never bring our case. At the bottom, sorry, could you read on? Yes, of course. There would be issues decided between the same two parties in the case. You could not relitigate them in the same case. It is obvious, insofar as defendants were then added to the pleading, if that was the outcome, it would be an obvious abuse of process for the claimant to try and run a second trial against the other proposed defendants, the other 5 proposed defendants, in which we tried to launch some sort of collateral attack on the findings of the first judge.
But that's not the problem, is it? The problem is the other way round. It wouldn't be an abuse for the defendants to challenge the findings as against.
You're quite. Yes, quite, my lord. That's correct. That's the position we say we're in this perverse position. But if you look then to the bottom of that page, please. On the most recent point, lastly, that was labelled by my learned friends. What is the prejudice if the trial goes ahead? Well, I'm going to come on to that. It is obvious that whether under the heading of the truth defence and the witnesses giving evidence on truth, or under the heading of the Section 4 defence, questions being put to the journalistic and editorial witnesses is obvious. They can put to them there was a conspiracy. My lord, we say that's simply not right. But if you look up the page, what Mr. Miller says, there is draft pleadings, that's what it says. And Mr. Miller says, well, we can just put the draft pleaded case to the witnesses. I'm now putting to you the central propositions in that draft pleading in cross-examination. The central proposal that a group of people who conspired to tell lies about Mr. Clarke and tell lies to the Guardian. The Guardian published the material in consequence. I'm going to put it to you that the conspiracy existed and you were part of it or knew it. We say that's a proposition which simply just doesn't hold water. Putting a draft amended pleadings is a dangerous proposition in a trial which is simply not there to deal with those issues without those defendants.
Well, I don't understand that. If the cross-examination of the witnesses is a witness is you've made this up, this is a fabricated allegation, then of course you'd be entitled to put the reason you say that the witness has made it up, i.e. that you've conspired with others to do so.
My lord, I accept that, but that's not the point I was making. Forgive me, maybe I didn't articulate myself very well, but the point is that as part of the trial, this trial, that we can put in the re-amended particulars of claim, which targets other defendants who are not at that trial, and start to ask questions about a case which is not even been formalised before the court. I mean, my lord, that would be.
But I thought your case is based upon the disclosure that's been given in these proceedings.
Yes, so far, yes.
So
yes.
why can't you cross-examine on the basis of that material?
Well, my lord, I am going to answer that question. I am going to answer that question robustly, if I may. But if I can just finish my point on this, I'm not ducking the issue, my lord. I will answer it. And
I thought that was the point you were making.
Well, my lord, I'll take that a little bit further. If I can just finish the transcript, I'm going to hit it head on, if I may. If you go to page 71 a bit further down, please, you'll see point 13. There is no prejudice in not being, page 71. There is no prejudice in not being able to put to every co-conspirator as a witness. In fact, it is very uncommon for the prosecution to be able to put it to every co-conspirator or defendant. My point is, we don't have the conspirators, the defendants in this trial. We simply don't have them there.
Well, you don't have all the alleged conspirators in the proposed amended trial, do you?
But we have the crucial witnesses. We have the crucial defendants in the amended pleadings. We have the witnesses that the defendants who we say.
Well, you've got six. You've got six of the conspirators, but as I read the pleading, you say it's a conspiracy that extended to perhaps 20 or more other conspirators.
Some of the witnesses are at the trial, my lord.
Yes.
Some of the witnesses, but the defendants themselves who have the crucial evidence haven't given witness statements in this matter. My lord, I'll finish with the transcript shortly, please, and I'll come on to answer your questions properly. My lords, can I ask you, please, I touch upon this now. You'll see at point 19, page 75, my lady, in regard to detailing the late disclosure point more fully, one example made of many provided is that particular matter that was disclosed, particular documents that were disclosed on the 11th of November were indeed referred to in the pleadings. And I hope this answers your question to some degree. Page 76, which is over the page at page 20, I am grateful to my learned friend, point 5, I'm grateful to my learned friend for raising the point concerning the issue of estoppel. If anything, that's a point, that if you're unable to bring the claim thereafter concerning the joinder of parties, then it makes sense for your lordship to hear the application concerning our amendment and joinder before trial. Point 23, I hope this answers your lordship's questions. Whether we would make cross-examination points, the court would not be entitled to the full facts of the matter concerning the conspiracy, and it would be a perverse issue where we would have witnesses giving evidence on the defamatory points that they have not really addressed the background to how they were contacting their current statements, and not giving evidence or not having provided evidence to their involvement or not in a conspiracy. There is simply nothing in their statements of how they were contacted or the relevant matters in relation to that point. My lords, can I just say this, please, in relation to the pleadings point on the delay? I can deal with that in my submission quite quickly. My lords, can I ask you please to go to the core bundle, please? My lords, can I ask you please to go to page 255? You will see at the top there, which was set out in the pleading case, paragraph 41. The first defendant's disclosure and thereafter the first defendant's witnesses served on the 5th of December have substantiated the claimant's contentions that there was a conspiracy to defame and damage his reputation. My lords, what I can deal with it swiftly. My lords, that's the pleaded case, the amended pleaded case. So the criticism of saying, well, and I'll go to her ladyship's judgment in a moment, well, your lordships would have picked up on it. And what she says is that we should have pleaded the case and got on with it months earlier. That's what she says. And my lord, I can meet that head on if I may, please. It may be obvious to your lordships, but if I could just make the point. Can I ask you please to go to the core authorities, please.
Are we putting the core bundle away for now?
I'm sorry?
Are we putting the core bundle away?
I was just making the reference to the plea. Yes, my lord, yes. So it's indexed to the core authorities bundle. My lord, this is the MBR case that Justice Warby referred to in his order. And what I say, which is relevant, my lord, page 88, please.
Try tab 5. Index says tab 6, but I think it's tab 5. Yes.
Thank you.
I'm grateful, my lord. This is the MBR case, and you will see there permission to amend. It's at point 26, take the following principles from Elite Property Holdings and Barclays Bank. There was no, paragraph 40, there was no dispute about the test to be applied in the circumstance of this case. It is important to bear in mind the overriding objective applies, and the question of whether permission to amend should be given must be considered in the light of the need to conduct litigation fairly. Obvious point, my lord. And this is where we say the merits are extremely important, notwithstanding the timing of the application. Over 89, please. A claim does not have a prospect where A, it is possible to say with confidence that the factual basis of the claim is fanciful because it is entirely without substance. B, the claimant does not have the material to support at least a prima facie case. My Lord, if you then please go to page 90, and this is right. 30, I take the following principles from Ivy Technology and Martin. Conspire to injure must be pleaded to a high standard, particularly where the allegations include dishonesty. Allegations of conspiracy to injure must be clearly pleaded and clearly provided by convincing evidence. My Lord, the point I'm making there is that I, or any member of the bar, have a professional duty to make sure if you're going to make these serious allegations, you do so properly. You do so based on the evidence and based on the disclosure. My point is, it's a simple one. We had the witness statements and further disclosure ongoing, but we had the witness statements on the 5th of December. At that point, notwithstanding we still hadn't had full disclosure, that is when, notwithstanding my client's instructions, this is a conspiracy, we could not professionally put proverbial pen to paper until after the 5th of December. And my Lord, in terms of the delay, I simply say this. Within 18 days, my learned friends, Mr. Lowe, Mr. Jeremy, such is life at the bar, my Lord, we were working sometimes 20 hours a day between the three of us, and we managed to put the pleadings together, lengthy pleadings with a big annex, within 18 days to the 23rd of December. It was impossible, in my respectful submission, to do it any quicker. It was just not possible to put these serious allegations based on disclosure and the evidence before that date. Perhaps we could argue maybe a day or two earlier. And so...
Well, that involves an assertion that you couldn't have started before you got the defendant's witness statements. Sounds rather improbable for an allegation by claimants, a claimant of a conspiracy.
Well, my Lord, I've already made the point. We didn't get one of the substantial pieces of disclosure until the 11th of November, and they were ongoing.
Well, that's November. That's not the 5th of December.
No, I accept that,
that's a month earlier.
But my Lord, for anybody to make these serious allegations, we wanted to see what was being said. There was extensions in terms of the witness statements, and we needed to actually plead the case before seeing what the evidence was. My Lord,
well, it's one thing to say you wanted to wait and see what was in the witness statements. It's another to say you weren't in a position to start drafting, let alone finalising a claim, until you'd seen the witness statements. Those two aren't necessarily the same proposition.
My Lord, that is not right. I would be misleading you by omission. That's not right, or it's not fair. My Lord, of course, we'd started to get the nuts and bolts of the pleadings together prior to then. We could not simply finish the pleadings until we seen the witness statement. So we had started on them, but we just simply couldn't finish it because we were still asking for the disclosure, which was relevant, my Lord. And my Lord, even if you're against me on that, so say, Mr. Williams, well, you had some of the disclosure, most of the disclosure in October. My Lord, we still did it within 2 months. We did it in 2.5 months. Notwithstanding the piecemeal disclosure, see, Your Lordship wants to say something. No, I'm sorry, apologies. But we say to crystallise it professionally with our duty to the court. That is what took up the time.
Mr. Williams, can I ask? These are all points which seem to me, although referred to by the judge, they really go to the merits of your application for an amendment and to join the new defendants. Surely the gravamen of your appeal here is that you weren't allowed to argue these points.
Precisely.
And that's surely what what this is all about, isn't it?
My lord, that's my point. Yes, I'm grateful. The point is, we weren't allowed to argue the merits. Can I take you to the authority in relation to that point, my lord?
Well, just before you do so, that may be your point, but the passage you showed us from what Mr. Miller said when the judge intervened showed that he was saying that the merits of the application were relevant to the decision she had to make on the 20th of January, and he explained why, because listing the application would necessarily prejudge the adjournment of the trial. It's not. It was your stance that you didn't have to address the merits of the application, but it was not common ground at the hearing before the judge, certainly so far as concerned the reasons for the delay.
My lord, I feel like I've in my submission, I've dealt with the delay points. I've addressed you as much as I can. The piecemeal disclosure, our professional obligations, and considering all the documentation.
Yes.
My lord, that was 2.5 months. My lord, that on the basis of a huge piece of litigation, thousands upon thousands of pages, having to cross-check and do it properly, my lord. That in my submission, we went as quickly as we possibly could, and we do say that I've seen the chronology, but notwithstanding the trial date, we say it was that side of the room in relation to disclosure, which was 2 months late. It was the disclosure was 2 months late, and we continually we're in this position where it's coming. When it came through, my lord, it was very, very complicated, and I can tell you why it was complicated. Is because there was huge redactions. There was recordings which didn't make sense. We had recordings which were generated by AI, which nobody could make head nor tail. Then we had to go back and ask for the transcript, then the recordings and cross-check. We still don't have those to this day. My lord, if I can please then just deal with some of the substantive points which you've questioned me in terms of the law of where we say we're at. The pinnacle, we say that the conspiracy started in 2019 based upon the disclosure that we have. My client had no more than a hunch. He wanted us to plead the conspiracy early. We couldn't. We just could not do it. But it came to a head just 11 days before the BAFTA award in 2021. So my client was due to get the BAFTA. We say that parties then reignited the situation, which only came from the late disclosure. And that award on the 29th of March 2021, and any contact with my client, we then say the three of the proposed defendants, labour the points, who are not witnesses in this case, it became clear upon disclosure that they were in fact involved in the malicious anonymous email campaign. And in the defendant's disclosure, we discovered that one of the proposed defendants, Miss Osborne, one of the defendant's journalists in their investigation, received numerous emails from Mr. Proctor, proposed fourth defendant, who acted as one of the defendant's confidential journalistic sources. And again, this came out, had to be cross-referenced, and they said, again, in the late disclosure, we're going to cut off Noel Clarke's oxygen supply, letting those above him, such as All Three Media and Sky, know who he is and that they should distance themselves. I'm not that emotional, I'm sort of very logistical. So rather than take people down emotionally, I sort of got them out logistically and started creating a sort of method which was to cut off Noel Clarke's oxygen supply. There was no way we could plead the case properly until we had that disclosure. That was then dealt with. There was a third article on the 3rd of April 2021. in relation to the mishandling of BAFTA, of the allegations raised by the same three journalistic sources, i.e. the three proposed defendants. The solicitors for BAFTA wrote a very precise right of reply addressing that these anonymous emails, etc., were false, and the reporters even cite the fact that BAFTA received anonymous emails, and it's true he did receive the anonymous emails. My Lord, if I could deal with just a couple of points to clarify what I've said, if I may, please. We do say we legitimately felt, because of the two orders of Her Ladyship, I hear what your Lordship say, but I just have to tell you the position we were in when we were before her on the 20th of January. We legitimately expected to deal with the directions in respect of the hearing of the application, i.e. we'll set it down for directions. That was the position we were in.
Set it down for directions.
Yes. She would set it down for directions on the 20th of January for the application to be heard. That's what she said in her order.
Well, give directions.
Give directions.
Yeah.
Give
No,
directions.
I'm so sorry. I'm not trying to pick holes in the language. I'm just trying to understand.
You're right.
Yeah.
It was my language which was poor. Set directions. Yes. I'm sorry. Forgive me.
Yeah.
On the orders 13th and 16th of January. And the reality is, we weren't, because of her order, we prepared the skeleton and we approached it on the basis that it was going to be set down for directions, not the substantive hearing or the directions in relation to, oh, well, we're not going to hear the merits till after the trial. That was a surprise to us. And my Lords, can I deal with the law on this point, please? In order to explain and justify the time of the application, a highly material factor when dealing with these kind of applications to amend made late, it's the Q Su Ling Goldman Sachs case. My Lord, may I ask you one moment, please?
I mean, they're quite familiar principles. I don't think anyone is going to take issue with the proposition that the lateness of an amendment is an important factor to be taken into account.
My Lord, I was just going through the motions in case you need me to take you to the authority.
But in your, have I got this right? In your skeleton argument for the pre-trial review, you said that lateness would be addressed orally at the hearing.
Yes, my Lord, and that's my point. When Her Ladyship said, she said it, I could take you to her judgment, if I may. She said this application to amend should have been made many months ago. I'm not too sure I can accept that right on any level.
No, I quite understand you take issue with that.
Of course.
What I'm examining is the prior question as to whether there was any unfairness in you not being in a position to address the judge about the delay involved. Well, and as I understand it, you said you would. It was in your client's evidence in the bundles, in the third witness statement to Mr. Clarke, and your pre-trial review skeleton said you'd address it orally at the hearing.
My Lord, I did to a degree, but the problem was this: is that the learned judge seemed to take Mr. Miller's submissions and form part of her judgment when she said, "Oh well, 99% of the."
I quite understand you say she got it wrong.
Well, of course, I wouldn't be addressing your lordship if I just said she did.
What I was cavilling at, but maybe it wasn't what you were suggesting. It was a suggestion that it wasn't something that the judge should have embarked upon.
No, my Lord, I simply say she got it wrong for the reasons I've addressed you, and she did get it wrong.
Can I just understand, you're not saying it was unfair for her to consider lateness? You're just saying she reached the wrong conclusion upon it?
Yes, because, my Lord, I may be quoting some obvious principles, but I can just set it out from the QSAR link. And we don't shy from the issue. A late application to amend is made the correct approach. Is not the amendments ought in general to be allowed so that the real dispute between the parties can be adjudicated on. Rather, a heavy burden lies on us as a party seeking a very late amendment to show the strength of the application, the strength of the new case and the issues, and why Justice Term, his opponent and the other court users require it to be able to be pursued. the risk is a trial date may be lost. The problem is that the application itself on the merits, and we say it's extremely strong. We can justify those pleadings on the merits. I know that's not what the court is here to deal with today, but to actually put that off till after the trial, when I say it's so inextricably linked, the conspiracy, and we don't even have the defendants there, we're going to have findings of fact, and we say they would be flawed because we're end up in this trial with draft pleadings on the conspiracy without the correct defendants in the trial, putting these arguments and these cross-examination questions, we can't possibly put them. So the merits of the application, in my submission, ought and could have been heard, and I'm going to come on to that heard before the trial dates, and I can address that head on if I may.
That must be that's the core of your appeal, isn't it?
It is.
I mean, nobody's suggesting, and you're not asking us to determine the merits of your application now. I mean, as I understand, the strength of your application is that you made this application almost 8 weeks before the trial, 8th of January, and that during that course of that 8 weeks, it could have been determined.
Yes.
That's it, isn't it?
My lords, it is. Yes.
And what's happened in the end is that the judge has not only, she hasn't refused the application because it was late, or because it doesn't have merit, or because of it will end up requiring the trial to be adjourned. She just hasn't heard it. That's
my lord,
the issue, isn't it?
Yes, my lord. Yes, precisely. That is the issue. My lord, if I could address that point, please. You will see. I can take you to it if you need to see it. But the proposed defendants, they said we need 3 to 4 weeks. We need 3 to 4 weeks to be able to deal with this. Well, my lord, I simply say, fine. They needed 3 to 4 weeks to deal with it. That was the 20th of January, but they had the pleadings at the latest on the 15th of January. And more importantly, they had the letter before action, many pages on the 23rd of December. And my lord, what we said, this was a simple, straightforward application to amend the pleadings, but the merits are crucial. Sorry.
When you say they, can I just be clear? All the proposed defendants had the draft pleading
Yes.
on the 15th of December?
Yes. Now, so my lord, sorry? I'm sorry. Forgive me, my lord. 8th of January. Right. 15th of January.
Well, was it the 8th or the 15th? I'm trying to...
I made a mistake. I'm sorry.
Yeah. No, I'm just trying to get the facts clear. I'm not complaining about mistakes. Just let's get it clear. You said that they had the letter before action on the 23rd of December and the amendments on the 15th of January.
Yes, at the latest on the 15th of January. The reason I say that is because Kingsley and Appy, who represent the other defendants, we've asked them, I think it's on 4 separate occasions in correspondence, when they received the amended particulars of claim. They won't answer us. They've told the court, it is our position by implication, without going through the correspondence now, trying to do a forensic analysis, our position, they got them earlier than the 15th of January, but nobody will tell us when they got them. But my lord, on the basis of the 15th...
I thought you sent them to the court on the 31st of December.
No, my lord. On the 23rd of December, the draft pleadings, the amended pleadings, were sent to the defendant.
Yes.
And at that time, there was also letters before action
To the
to
proposed
the proposed defendants.
Yes.
And
Then the application was issued on the 8th of January.
It was formally, I think the word stamped from the court was on the 8th of January. Yes, my lord, but it was a few days early we'd put it into the court. My lord, the point I'm trying to make, if I may, please, is that by the 15th of January, the proposed defendants had everything, including the letter before action, setting out in great detail, and it was their position.
So the draft pleading was separately served.
Yes.
On the 15th of January.
Yes.
On the proposed defendants.
We suspect that they had them earlier, but I can't say.
I understand that's what you say.
So on the 15th of January, they said in court before Her Ladyship, we need 3 to 4 weeks.
On the 15th?
On the 20th.
20th, before Her Ladyship, we need 3 to 4 weeks. My lord, fine. There was no issue with that. The 3 to 4 weeks would have taken that to the 12th of February.
3 to 4 weeks to do what? To consider
The application. So
The
they said
application.
in order for us to be able to have to respond to the application or have the application heard, it's in the transcript, and we need 3 to 4 weeks. Even if we take it to the 4 weeks, my lord, that is the 12th of February. We simply say, for all the circumstances of the case, and having dealt with the lateness, it was not our fault, having worked tirelessly to go as quickly as we could, then it could have still been heard some 3 weeks before the actual trial date.
Well, the judge thought that on what she'd been told, if all the proposed defendants were involved, it would need 5 to 6 weeks. And was that a view that she was not entitled to reach?
Well, my lord, potentially it could have been, but that's set against the background of us saying, well, no, this can be dealt with as a straightforward application.
Without the other defendants?
No, with the other application. I'm answering you, my lord, I really am.
Sorry.
We say that the application could be dealt with, we say, quicker, but the defendant's position was we need 3 to 4 weeks. So that was their representations to the court. My position is, whether it's 3 weeks or 4 weeks, we would have still, the latest date to deal with the application would have been the 12th of February.
Was the 3 to 4 weeks in order to take it up to we can be ready for a hearing in 3 to 4 weeks, or was it 3 to 4 weeks to consider and digest it and decide what evidence we might want to put in response? Obviously, there's a difference. You'll be able to tell me which one it was.
Well, my lord, if I could say, even if it's on the latter case, they need 3 to 4 weeks to respond. My lord, if they were given, say, for example, 3.5 weeks, and we said they've already had the 5 days prior to, and we suspect earlier, and and the letters before action, even if they needed 3 to 4 weeks and it was listed a week later or 4 days later, my lord, in any event,
responsive evidence, time for you to respond, or not?
Well, my lord, there were very extensive pleadings. Any response would have been minimal, in my respectful submission. We're only dealing with the amendments of the pleadings. Excuse me, sorry. Yes, sorry. Yes, and the Joinder application, my lord. Even if we stretch it out, my lord, that application could and should have been heard at least 10 days ago, 2 weeks ago. My lord, can I just go to the heart of it? Because it is a peculiar situation. There's no authority on this point. My lord, if we can just touch on some points, please, just to assist you with your decision. Some of the points I've touched upon, but I'll do this relatively quickly, my lord. It's the res judicata point, the issue of estoppel. You see, I've dealt with that in our skeleton argument. That's at page 27. Sorry, forgive me, paragraph 27 and 28 of our main skeleton argument. And it doesn't matter how we dealt the issue. It's my learned friend's position. That was their intention to rely on res judicata if we actually went to a second trial date. My learned friend may be right, may be wrong, but there's no doubt they said they will raise it as res judicata. That puts us in an impossible situation, because what they said, if I can quote, if there were findings of fact in the March trial on the truth of the defamatory meaning and whether this was a lawful public interest to set up publications by the Guardian, any attempt in the latter trial, as between the defendants and the Guardian, the claimants and the Guardian, we would say that the claimant and the Guardian, Mr. Lewis, as the Guardian's proxy, any attempt to try and reopen those findings of fact and law would fail, because it would be res judicata. They would be issues decided between the two parties in the case, and you cannot relitigate them in the case. It is obvious.
Yes, you've shown us that passage.
Yes, my lord. The issue of estoppel arises where the points are raised in the subsequent proceedings, but we're in the position where my learned friend said, well, you haven't really got the proceedings, but they can form part of the trial, and they're not raised earlier, and they were raised unsuccessfully. Lord, it's important because I saw Lord Justice Warby's point, but as we set out, defamation and the conspiracy arise from the same factual matrix, but the defamation was the means from which the conspiracy came to fruition. And we say you cannot fully understand all those issues concerning defamation, especially the public interest defence, without understanding the conspiracy. You just say that's just an impossible point. However, owing to the fact that the conspiracy point had not been properly presented and has not been properly presented and argued, and evidence before the application to amend and join, and it may require further disclosure, we don't know, but we're in a position we can do it on the present case for the reasons I've explained. We've worked tirelessly to get it up on its feet. We would be unable to cross-examine the relevant witnesses. We don't have the witnesses, we don't have the defendants to put at this trial. And the potential witnesses are not being called by the defendants. As such, the trial and the defamation, the judge will be making findings of fact which impinge upon the conspiracy claim. And we say it's self-evidently unfair. My Lords, I'm not going to go through the res judicata point. I think I've dealt with that as much as I can for the present purposes in case I need to reply. But my Lord, can I deal with the cross-examination point, please, on the unpleaded case? Again, we had set it out in our skeleton arguments. We said it is obvious that whether under the heading of the truth defence and the witnesses giving evidence on truth, or under the heading of the Section 4 defence, questions being put, the journalistic and editorial witnesses, it is obvious they can be put to them that there was a conspiracy. That's the position of the defendant. That's just not right. We say this proposition is wrong in principle. The abilities of parties to cross-examine witnesses is not unfettered. Rather, it is subject to the court's inherent power to control cross-examination. And my Lord, I think the point is probably obvious, but if I may just quickly deal with it in a few moments. It's the case in Cristoforo that established no more than the proposition that when a topic is properly raised at trial, challenges by cross-examination should be permitted. It did not establish that a party should be allowed to ask in cross-examination questions about any topic, i.e. a topic which doesn't form part of the case, which he or she wishes. The true position is the reverse of that, and the court has the power to limit cross-examination. But my Lord, this is what is said. Again, it's an obvious proposition, and it's the Rolled Steel Products Holdings Limited, which is before you. And the proposition there, it says, pleadings regulate what questions may be asked of a witness in cross-examination. If a line of questioning is stopped because it does not relate to an issue on the pleadings, counsel should at once consider whether his pleading should be amended.
Your point is the opposite of that. Everyone's saying you can cross-examine on all these issues. You're saying you can't. So you're not complaining about being stopped. You're complaining about being told that you can.
Well, my Lord, it's a position we say, even if my learned friend says, oh, okay, you can put in your draft pleadings and you can cross-examine everybody on the draft pleadings, we say that's a very dangerous position. It's a rather curious precedent which is being set.
That's about the mechanism, isn't it? The real question is whether, on the issues as they stand, the scope of your cross-examination would, contrary to the view of the judge and the defendants, be unfairly curtailed in such a way that you risk findings that would be different from the ones you would achieve in a full trial.
Yes. My Lord, the point is, I can only, no point in repeating it, my Lord, the actual conspirators, the defendants, are not part of the trial.
But so are lots of the conspirators not part of your case.
No, quite, but my
Lord,
Lord,
sued them. So,
but my Lord, the ones that we've pleaded,
yeah.
We say the evidence against them on the merits is very strong indeed, and so we would be there with them not being there. We elect who we've sought to claim against, but my Lord, it is a proposition which, if I may say, is odd. And my Lord, we simply, sorry, if I could just finish that part. If he decides that he should forthwith apply for an amendment and should specify precisely what he wants, and the judge should want to give a ruling on the application. And my Lord, this is about as unambiguous as it gets. One's ability to cross-examine is railroaded, we say, by these pleadings, but to actually bring in draft pleadings and say, well, Mr. Miller's given you permission to bring in the draft pleadings, we're still hamstrung, absolutely hamstrung. It's just simply not fair. And to actually go outside the pleaded case and start asking questions and then saying to it, the court, well, actually, if you look, this is what's in the draft pleadings, that's why I'm putting it to them. My Lord, it would be most curious.
That's not the way you do it. Surely not the way you do it. You would be putting propositions to the witnesses and showing them documents to establish that their evidence was not right.
My Lord, but I simply say that even if that was the case, that we wouldn't have the other defendants on the draft pleadings to actually be able to make out our case properly. My Lord, I'm labouring the point. But my Lord, if we're unable to cross-examine the journalistic sources, the editorial witness on the conspiracy claim, we say it creates an absurd situation if the application succeeds subsequently to the trial on the current pleaded issues. We say they may have to be recalled in relation to the conspiracy claim, which with the new defendants. Well, that is a realistic position. And they're not completely conterminous with the matter. Can you just give me a moment, please? Yes. Sorry for you. My Lord, Mr. Lowe, Mr. Jeremy, just pointing out that the witness statements don't deal with the conspiracy.
But you don't need to labour the point that in an ideal world, all related issues should be tried together in one action with one set of evidence and one set of findings. There can't be much controversy about that. The question in this situation is whether or not the timing was such that your contention that you should be able to add these new claims against these new defendants couldn't be determined before the trial. And that's the issue, isn't it?
Yes.
And the only issue.
My Lord, yes. We're left in this bizarre situation where the merits has not been heard, and we simply say the merits could, should, and were able to be heard prior to the trial, but to actually say, well, we'll listen to the application after the trial for all the reasons I've said is his position, which is simply not right. My Lord, if we can finish on just a couple of points, if I may, please. In terms of the pleadings, the conspiracy touches upon 29 of the 34 respondents' witnesses and at least 15 of the defendants' witnesses, but the further 3 proposed defendants were not served as hostile confidential journalistic sources within the conspiracy.
So when you say it touches on, does that mean that there are, by your tally, 44 conspirators?
No.
What?
No, sorry.
When you say it touches on,
So
29 of one side's witnesses and 15 of the other side's, what do you mean by that?
Well, there's 15 of the 34 witnesses. So maybe my note's wrong, forgive me. Notwithstanding the further 3 proposed defendants, which were served as hostile confidential journalistic sources within the conspiracy, my Lord, the point I was trying to make, they are factually connected, but it's important to bear in mind that legally the defamation and the conspiracy claims are distinct claims, separate. They are separate claims. The former cause of action does not subsume the latter, which is set out in the Kuwait oil case, which His Lordship pointed out, and that was in relation to the Australian case of Pioneering Concrete. And if I can quote from that, there seems to me no convincing reason why it should not be open to the plaintiff to sue the alternative both on a conspiracy to commit a tort and on the joint tort. There are many instances where the courts have countenanced an action on an unlawful act conspiracy to commit a joint tort without any concern that the so-called doctrine of merger prevents that course being followed. and it sets out the alternative causes of action. My Lord, in relation to the 29, arguably fell into the common design. 15 intimately involved in the conspiracy. 15 were involved in the conspiracy. My Lord, I put together a further supplemental bundle. I haven't addressed it at this stage because my learned friends sought to put the strikeout judgment in the bundle, which no doubt, sorry, put it before the court. My Lords, I have my position is that was some 2 weeks later, that judgment, and is not strictly relevant to this application. But my Lord, to be disingenuous for me to say that too has been appealed. We said there was a significant error of law, but we have answers to that point. If I could just deal with that point very quickly, and I'll sit down if I may, please. My Lord, do you have the further supplemental bundle before you?
Yes.
My Lord, can I ask you please to go to page 65. I deal with this quickly because one of the, my Lords, before I take you to that, if I could just crystallise what the learned judge said. The learned judge set in her judgment that Mr. Popllewell and Miss Osborne could not have known or could not reasonably have known about contemplation of litigation. That was one of her findings in her judgment. And that's why one of the basis, one of the planks why the striker application wasn't heard.
At the time that the destruction, at the time the documents were destroyed.
Yes, yes. My Lord, we now have, again because of disclosure, we now have, in fact, and there's been a submission made to the learned judge. In fact, we found out that there's a recording, which was not before her ladyship, where they said, okay, essentially admitting that they're going to be sued. That wasn't raised before her ladyship, and those facts were not before her. We hadn't known about that at that stage. And the reason I raise it gently, because in fact it wasn't correct. They've admitted with their own language that in fact they knew they were going to get sued, and they knew they were in problems. And why that's important, because the next day they then delete the evidence. That wasn't before her ladyship. And that's why I say we should tread cautiously.
I just understand, you're going back to the judge. Are you making an application to the judge for her to reopen that application?
My Lord, at the moment, I'll tell you what we've done at the moment.
Just want to understand the facts.
Yeah, my Lord, the answer is yes. Full force, yes, because we had to make cost submissions and this correspondence of where we say she was misled. Certainly don't accuse my learned friends of deliberately misleading her, but the reality was that she was misled by omission. That, in fact, the very basis of her judgment was based upon they did not know or could not reasonably have known of the litigation, when in fact we've sent the letters to her as part of the cost submission.
So just so I understand, and mind the detail of the grounds, you are going to be asking before the trial starts
Yes.
For the strikeout application to be revived,
Yes.
and for the defence to be struck out.
Yes. My Lord, we have to, because that was
I just wanted to be clear that's
yes,
what's happening.
yes, my Lord.
Now we've come to the end of your time, I think. But I there's just something I wanted to ask you.
Yes.
We've been addressing entirely understandably what the position was before the judge on the 20th of January.
My Lord, may I just ask for some water, please? Sorry, my Lord, I am...
I'm sure someone will
yes,
find some for you.
Mr. Lowe.
Can I just ask what you're asking us to do as we sit here now? I see your notice of appeal in the form of relief you're seeking simply ask for an order that the amendment application be listed for the earliest available date. But can I just explore what that means? Because presumably we would have to consider what directions would be needed and what that date might be.
My Lord, can I be frank with you? That's one of the biggest issues I've been wrestling with on my side, certainly for the last few days,
Yes.
in light of where we are today, not yesterday. But I have to stand by that application, because otherwise it'd be a nonsense for me to say, that it can't be dealt with. We say that it should be dealt with prior to the trial. That's the whole basis of my application.
I understand that, but you're asking us to make an order.
I am.
And if the application is going to be heard, as the judge thought it ought to, with the participation of the proposed defendants, realistically, that doesn't mean until sometime well into the trial window.
My Lord, I have to accept that's a distinct reality.
Yes.
My Lord, I simply say that's not our fault. We didn't.
I understand that, but the reality is that you are asking us, in substance, to adjourn the trial, are you?
My Lord, that's a likely outcome. I'm not being shy about it. But my Lord, for all the reasons I've set out, that the prejudice to the claimant of not, for all the reasons I've set out, for the claimant not to be able to put his case properly far outweighs the position that we're in. And
Forgive me, you've made it plain that success in your application would probably mean adjourning the trial. But I'm not sure you've said expressly that success on this appeal would mean adjourning the trial. And are you accepting that would be the case?
My Lord, it's a matter for your lordships, of course.
Well, no, it's
my Lord,
important for us to understand what your position is.
Well, our position is that this application to amend should have been heard before the start of the trial, and we say we've done nothing wrong. We did everything proper. We did everything we possibly could. And yes, the consequence in reality is that the trial may be adjourned. But my Lord, that we say.
So the question is this: are you contending before us today that if we allow the appeal, your application could be heard and determined, and you still have the trial starting on the 3rd of March?
Well, my Lord, the answer to that question is, if for example, the appeal was allowed and you directed that this application should be heard, my Lord, can I just interject what I was about to say? On the basis of the proposed defendants have now had more than what they requested, that in fact, if it was directed that, for example, they were to serve their evidence in response to the application, for example, by next Wednesday or Thursday, and then the application could be heard at the beginning of the trial. My Lord, I say that with a caveat because in reality, the learned judge there's 2 reading days for the proposed trial. There was a debate, and I can say from that side of the room, they thought that the trial may go shorter. It may well go shorter. And we may lose the first few days or the first week of the trial, but there's no reason why the trial.
Reading days, the 3rd and 4th.
The reading days are the 3rd and 4th, yes. And my Lord, but even if we had to push the trial back a week, but the reality, since the judge will either allow the application. Sorry.
That's on the hypothesis that the application is being dealt with only vis-a-vis the existing defendant and not with the participation of the other proposed defendants.
Well, my Lord, I'm not sure about that because I've just addressed that quickly. That if the proposed defendants, now they've had the time and it was directed, look, this application should be heard. I don't know, my Lord. So if it could be heard and dealt with within the next 14 days, the application.
Let's see how they had the time, because on the 20th of January they were told they didn't have to file any evidence.
Didn't have the
didn't have to file any evidence because it wasn't going to be dealt with until after the trial.
Well, yes, I get, my lord, I accept that. But the reality is they said, that's what they said, and I accept it, that they needed 3 to 4 weeks. Well, they've had 5 to 6 weeks.
No, they still need 3 to 4 weeks because they were told they could down tools.
My lord, I think the reality is that I'm going to be in some difficulty of saving the trial. I'm not saying it's impossible, it's a matter for the judge. But my lord, I emphasise, we did not want to lose the trial date.
So I understand you say we shouldn't be here. I'm just looking at the realities of what you're asking us to do now that we are here.
It's not, professionally, it's not nice for me standing on my feet saying, look, I'm well aware of the resources of the court and all the obvious points that trials should not be vacated, but trials are vacated. Trials are vacated, and it's not a nice proposition to be putting before the Court of Appeal. But
why should you not say we made an application to amend and to add parties on the 8th of January? The judge should have given directions to determine that. She didn't. We now find ourselves here. If you accept Court of Appeal that we should have had a right to have that application heard, the consequences must follow. And you seem to be timid about saying that.
My lord, the only reason I'm timid about saying that is because I'm not entirely convinced that the trial will be lost. All I'm saying, part of the trial timetable will be lost. But I'm facing the reality, my lord. Yes, the trial may.
You also don't seem to be saying that I thought you were, but you don't seem to have said to us today, no, the new proposed defendants don't need to be there.
Well, my lord, that is our position, and I've dealt with that in my grounds of appeal. But I
thought in the oral submissions to us today, you've effectively accepted that they would have to be there.
Well, the only reason I've done that, my lord, I'm sorry, I apologise. The only reason I've done that is looking at the longer picture, the wider picture, if there is an invitation to that. We simply say, how can parties who are not parties, who my lord, can I just point something out, please? Well, what the learned judge said. Can I ask you, please, to go to the judgment? My lord, it's in the core bundle index. Sorry, forgive me, page 46.
Yes. Which paragraph do you want?
Sorry, please. Paragraph 11, page 48.
Yes.
I accept that the failure to serve the proposed new defendants does not put the claimants in breach of any order, but that does not mean the application was filed and it has not yet been served on the 6 persons who are respondents to it. My lord, I simply said that the learned judge was wrong. We set out quite clearly on our written arguments that they should not have been defendants at that stage, or even respondents.
You have, but I don't think you've challenged the exercise of discretion in paragraph 10 of the judgment, in which the judge says, if it were necessary, I'd direct that they should be responders to the application. And I don't think there's any dispute that she had jurisdiction to order that under Part 23.
My lord, you're right. I don't challenge that.
And that's why it didn't surprise me hugely that you were starting from the proposition that the application then, and indeed now before us, needs to be dealt with the defendants present. You say it could perfectly well have been done as of the 20th of January, and you say, well, it might be more difficult now, but you certainly wouldn't concede that it can't be done and would inevitably lead to the adjournment of the trial. Have I understood your argument correctly?
Correct, my lord. It was a more subtle point in that, on the basis that we'd done nothing wrong, the judge said is that we got a costs order against us for not breaching any rules. for the defendants turning up. That was the subtle but important point. I can't simply suggest that in the discretion of the judge, I direct you to serve it upon them. Yes, and also that's one of the problems, is that the direction of that is it'll be served on them 7 days after the trial date.
Well, that's the necessary consequence of her decision on the...
It is. I'm afraid she was wrong. And for us to be hamstrung and be in this position and troubling your lordships, for all the reasons I say that the appeal should be allowed, is there anything in particular that you would like me to...
That's very helpful. Thank you very much. Yeah, thank you.
My Lords, I want to start to look briefly at the current state of the pleadings and then exactly how the claimant proposes to amend in the re-amended particulars of claim. I do that partly in order that the court can see how complicated and contentious the new claims amendment application is and would be. And also to make the point the judge had the pleadings and the proposed pleadings in the PTR bundle, as well as the trial witness statements. She was the trial judge, she had the full picture, and would have had in mind what was involved in the exercise of trying to get the amendment application up and running and resolved. There are some other points where it's relevant to look at them. One issue we say, and I'll come on to this, is there are other different amendments that could have been made to the amended reply, without introducing other defendants, to introduce into the libel case, in substance, the matters that the defendant, that the claimant wants to put to our witnesses, by way of response to the Section 4 defence and the truth defence. I'll come on to that. But they've definitely chosen, as it were, the long way round as far as the libel action is concerned, to put themselves in a position to challenge the two defences. The other preliminary point I wanted to make is that some reference has been made to certain persons being our journalistic sources. The Guardian's position, the court will understand this, is that we do not confirm or deny the status of any source who's a confidential journalistic source. And the redactions that Malone Friends referred to in the documents when disclosed were made specifically on that basis, that they were necessary to protect the identity of confidential journalistic sources. The redactions have never been challenged since October. Starting with the amended particulars of claim, which is in the core bundle, the court will have it in mind that the most important defamatory meaning is in relation to Article 1 and is at paragraph 7, page 59, which if you're working from tabs is tab 8. And it is essentially strong grounds to believe that the claimant engaged in unwanted sexual contact, sexually inappropriate behaviour and professional misconduct towards women. I'm paraphrasing it there, but you can read the meaning that Mr. Justice Johnson determined. The account of the amended defence, which is at tab 9, and simply observe the data protection claim adds nothing to the issues raised in the libel claim. There are technical reasons why that's so, but I will concentrate on the libel claim. Starting at page 163, paragraph 17, we, in the truth defence, which the judge has said should be tried, we plead allegations of misconduct in relation to 22 women. The court should note, and their cases are pleaded as their cases under, at the time it was pleaded, pseudonyms. Don't worry about that, but that's been overtaken by events. Some retain pseudonyms for the trial, some don't. There are 22 women's cases. Another woman agreed to give evidence of misconduct against her just before the exchange of witness statements. And it's been agreed her witness statement would go in without further amendment to the pleading. So there are 23 women, all told, whose cases are going to be an issue. We've served witness statements from 28 truth witnesses to prove these allegations in the cases of the 23 different women. The defence of publication on a matter of public interest under Section 4 of the Defamation Act 2013 begins at page 104. Begins at paragraph 104, page 182. The court will be aware there are 8 articles in issue. There's a pleaded account of the defendant's investigations and decision-making in relation to each of the 8 articles. So it goes through each of the 8 articles and sets out what the defendant's investigation involved and what its thinking was. With one eye on the draft re-amended particulars of claim, which we'll come to in a second, please could you look at page 182 to paragraph 107 in the Section 4 defence, which identifies 2 people, Sally El Hassani and James Christian Floyd, as the defendant's initial sources for the investigation. They were BAFTA members who knew of allegations of sexual misconduct against the claimant. The response to the truth defence in the amended reply starts at page 204, that's tab 10. And the way it's pleaded is that the claimant pleads to the specific allegations of misconduct in each of the 22 cases, but does not plead that the allegations are the product of a conspiracy in which sources lie to the Guardian about the misconduct. Rather, common recurring plea is one you can see at paragraph 6 on that page, which is the bare denial. So he says it's pleaded the claimant did not behave as alleged. And that's a phrase that's repeated on a number of occasions throughout the cost to the truth defence. It's a bare denial. The response to the Section 4 defence, starts at page 230. We don't need to take it in again in any detail, just so you have it in mind. Various criticisms are made of the investigation and right to reply process, and paragraph 103 on page 233, it's argued that there was no public interest in the journalists investigating Mr. Clarke where the police hadn't done that. But again, there is no plea that the Guardian published the articles in pursuance of a conspiracy by others to lie about Mr. Clarke in order to harm him. The proposed re-amended particulars of claim is at page 239, tab 11. It's mistitled, just for the record, re-amended claim, but there hasn't been a re-amended claim yet. And you can see on the title page the 6 proposed new defendants. They are would-be defendants 2 to 7. So Paul Lewis oversaw the journalistic investigation of the 2 journalists, Lucy Osborne and Sirin Stewart, professional name Cale, in his editorial capacity as head of investigations at the Guardian. He is a witness in the Section 4 defence, as are each of the 2 journalists, Ms. Cale and Ms. Osborne. Defendant 3, Gina Powell, Willow in the pleaded defence, but she's now able to be publicly named. Gina Powell is a truth witness as to the allegations in her case. Defendant 7, Jing Lucy, referred to as Charlotte in the original pleading, is also a truth witness as to the allegations in her case. The defendants 4, 5 and 6 are not, and as the court knows, defendants 5 and 6 were the original sources that have been named in the defence. I'll come to their position in due course, and the complaint that the claimant makes about them not being parties, and so not parties or witnesses. The structure of the amended parts of the pleading, dealing with the new claim of unlawful means conspiracy, is, and the court may have seen this, so I'll take it shortly, starting at page 254 through to 258, a case in conspiracy is pleaded against each of the 7 defendants, following a summary on those first pages. So there is, which is probably the most important thing to look at, there's a summary on those pages, and then you get, in the following pages, a case against each of the proposed new defendants. And that's supplemented with further particulars of aspects of the case in a series of annexes at the end of the pleading. Paragraph 41, which you were taken to, looking at the end of that paragraph, you'll be able to see that the 2 reporters, Lucy Osborne and Shearing Cale, are characterised as the Guardian's agents. We're not entirely sure in what sense it's being said they're agents. But as I've said, they are also witnesses at the trial. Importantly, the premise for the case against the Guardian, and indeed the proposed second defendant, Mr. Lewis, and those journalists, the agents, is in the summary that I've told you about on page 257, at paragraph 58. And it's 58A that's important. The 3rd to 7th defendant's common objective of the conspiracy was to cause irreparable damage to the claimant's reputation and consequential financial loss. They attempted to achieve this by defaming the claimant, by acting as journalistic sources for the first defendant and its agents, including the second defendant, effectively relaying or reporting on false allegations of sexual misconduct. So the conspiracy case is kind of split into 2. There's a premise, which is they're feeding false allegations of sexual misconduct to the Guardian, and you then come to the case against the Guardian. And we're going to look at that now. The case against the Guardian, Mr. Lewis and the agents, is unclear. In the summary at 59, we get the summary of the case against those parties, the existing defendant, Mr. Lewis and their agents, and it is, well, you will read it. It's an equivocal plea. It's about as equivocal as a plea can get. They were, or ought to have been, aware of the conspiracy, is the first proposition. That is the D3 to 7 conspiracy to relay the false allegations, which of course seems more like a complaint of negligence if you're looking at the proposition they ought to have been aware of it. There are other possibilities there which we don't entirely understand, but they lead at the other end of the spectrum to the proposition, bold proposition, that we were eventually parties to the combination. You get that at the end of the paragraph, which we take to be an allegation that we, the journalists, joined in the 3 to 7 conspiracy. As to the case pleaded later on against each of Paul Lewis and the Guardian, paragraph 131, which is where you get the longer form of the case against them, on page 270. This is the case against Mr. Lewis. The unlawful means conspiracy tort, of course, requires for each conspirator an intention to harm the claimant. But there's again an equivocal plea here on this point in the case against Mr. Lewis. It is said that he either self-evidently intended to harm the claimant by overseeing the investigation and the publications, or he ought to have known that the claimant would be harmed by the conspiracy. There are no particulars of the allegation that Mr. Lewis acted with this intention anywhere that we can see. Critical point in the plea, no particulars. Note also in that paragraph that there's an allegation of dishonesty in the third line, where it says, including by way of dishonesty and bad faith. Again, without any particulars, quite contrary to the established principles of pleading, that you provide proper particulars of dishonesty and bad faith. Against Mr. Lewis, the claimant alleges two unlawful means beyond the central or supposed unlawful means of publication of defamatory material about him, which we've seen. These are essentially, if you look at page 270, beginning at paragraph 132, attempting to pervert the course of justice by deleting and fabricating evidence shortly before the publication of the first article, when he knew that libel proceedings were being contemplated. There's a lengthy plea at 132 to 136 to that effect. At 138, under the heading Anonymous Emails, there is an unparticularized allegation of involvement in unspecified statutory digital communications offences. And I won't take you to it, but in the supplemental skeleton, paragraph 2, that the claimant filed yesterday, he points to the fourth witness statement of Mr. Clarke, which was before the judge, paragraph 14, which suggests that these were malicious emails to third parties in the industry, to BAFTA and television and production companies, not G&M. Now, we don't accept there were any malicious emails, but we would say, in any event, it's not clear what this has to do with the libel action or the damage caused to the claimant's reputation, which is said to be the harm intended by the conspiracy into which we're supposed to be dragged in. Our point in relation to these two other means pleas is that neither of these were the means that caused the loss, which of course is one of the core requirements of an unlawful means conspiracy. You identify the means that the conspirators will use to cause the loss and characterise it as unlawful. The loss is said to have flowed from the simple fact of the publication of the Guardian's article. So these pleas, which are substantial, add absolutely nothing to the claim except to prejudice the Guardian and Mr. Lewis in the eyes of the world and the court. Regarding the first allegation, the deletion and fabrication of evidence amounting to an attempt to pervert the course of justice, the judge gave a judgment on the 5th of February 2025, as you know, dismissing an application by the claimant to strike out the defendant's defence on the basis of these allegations. The decision is in the further supplementary bundle, tab 3, page 59. And if you turn to paragraph 73, which is at page 59, as I say, 58 to 59, she very straightforwardly held that the application to strike out, which was on the basis of the supposed attempt to pervert the course of justice, failed at the stage of lack of intention to pervert the course of justice. So she found no evidence, sufficient evidence, to establish an attempt to pervert the course of justice. Worse than that, at paragraph 76, she recalls that in oral submissions, counsel for the claimant sought to assert that the term fabrication, because there was also an allegation of fabrication of evidence against Mr. Lewis and the two journalists, was justified. Her ruling on that was, in the second half of the paragraph, that that was unacceptable. Deletion is not fabrication. There was no evidence of fabrication. And such a grave allegation should not have been made and publicly aired without foundation, yet it remains in the pleading. It hasn't been taken out of the pleading. Then if we go back to, I'm sorry to make you jump around, I'm trying to avoid it and will avoid it, I hope, from here on in. If we go back to the core bundle, at page 274 in the amended pleading, we get to the plea against Mr. Lewis regarding the publication of the defamatory Guardian article. At page 274, paragraph 150. At subparagraph A, there is again an equivocal plea that one becomes familiar with if you read through this pleading. The second defendant, Mr. Lewis, knew or ought to have known, or was reckless to, the false allegations that were created and relayed by the conspirators. There he is, he's sitting doing the investigation as an editor, he's approving publications and warranting them to the editor. And it's not even clear when he's supposed to be in this conspiracy whether he knows, ought to have known, or was reckless as to the fact that he was being fed false allegations by the 3 to 7 conspirators. There are no particulars of knowledge, again in flagrant disregard of the rules of pleading, to the extent that allegation is pursued. And then at D, it's pleaded again against Mr. Lewis that in committing the tort, the defamation tort, and allowing or facilitating the publication of the defamatory articles, he was acting with dishonesty and bad faith. Again, there are no particulars here of dishonesty or bad faith.
Sorry, where are you in the pleading there?
D.
D.
274.
Oh, sorry, I thought you'd made that point. Thank you.
No, it's a different plea.
Yeah.
Regarding GNM, just again a few brief points. Page 275, so we then come on to the case against the first defendant. That's my client and the current defendant in the libel action. At 155, we get some more particulars of the case against the Guardian. And it needs to be looked at very closely because it's very odd. This was that Paul Lewis was the guiding mind. This is 155A. The body of 155.
Yeah.
Lewis acted as the guiding mind of the first defendant in the defamatory publications. And was a party to the conspiracy, this is A, and or acted and collaborated in the common design of the conspiracy. He was the guiding mind of the persons by whom the significant decisions to publish were made. Now, those people aren't specified here in the pleading. On GNM's case, they included the editor-in-chief, in respect of the first article, and her deputy for one of the later articles. Both the editor-in-chief and the deputy, Mr. Gibson, are witnesses on the Section 4 defence. There is no substantiation of this guiding mind assertion. This is important. So there are no particulars as to how or why Mr. Lewis is supposed to have been able to persuade the editor of The Guardian and the deputy editor of The Guardian to publish allegations which on one form of the claimant's case he knew were false. No particulars. At 155A, as I say, we get another form of the equivocal plea, and that seems to be suggesting a case, at any rate, is that we were simply the vehicle for the conspiracy of 3 to 7 to be put into effect. Maybe not an innocent dupe, maybe a negligent dupe. I'm not really clear what's being alleged. But that's the phrase, the elusive phrase, or acted in the common design of the conspiracy. We have no idea what that means. And lastly, as far as the Guardian is concerned, at 159, on page 276, it said that the actions of the Guardian in publishing the articles, which is the absolute crux of the case, it's what's supposed to cause the harm to reputation, self-evidently support an intention to injure the claimant. But of course, they do not self-evidently support this. They more likely show an intention, we say in the public interest, to publish newspaper articles about him following a journalistic investigation. Such articles often harm somebody's reputation, but it doesn't mean this was the intention in the sense envisaged in an unlawful means of conspiracy to harm the reputation. So again, there should have been particulars here. There should have been particulars saying why the intention of the Guardian, of those editors, was to participate in the conspiracy and harm the reputation of the claimant by publishing false allegations. And they simply aren't there. The case against the defendants 3 to 7, frankly, is too long and convoluted to go through, and we don't have time to do it. But the central allegation is the one that we saw at 58A in the summary, namely that they combined to relay false allegations of misconduct about Mr. Clarke to the Guardian. Regarding the falsity of the allegations, claimant seems, as far as we can see, to rely on his pleaded case in defamation, which you will recall is, I deny that any of this happened. But this won't do. There is a presumption of falsity in defamation. So the claimant can sue on allegations, on a presumption that they're false. Lord Justice Warby well knows there is an operative presumption. But there's no such presumption in the law of unlawful means conspiracy. So he should have set out the published allegations, which he says are false, and why they're false, and more importantly, who was responsible amongst defendants 2 to 7 for relaying each of those to the Guardian. It would be impossible on the basis of this pleading, were it to come to pass, that each of defendants 3 to 7 to respond to this pleading. It would be impossible for them to know what it is they're alleged to have done by way of passing on false allegations to the Guardian. Which allegations did they pass on that were false? And why were they false? There's nothing like that in this pleading. The pleading provides no basis for what is inevitably an inference that these defendants, 3 to 7, did what it's alleged they did in combination with the intention of harming the claimants. Now, it's not in dispute that numerous sources, mainly women, have made allegations to GNM about sexual misconduct by the defendant. If we go back to paragraph 46 in the summary, which is at page 256, the court will see that the claimant tries to bring into the conspiracy, in some form or other that we don't understand, 17 women and 1 man whose allegations are in the truth defence. So in that list of 23 cases of women that we pleaded, in some way or other. You could read this and try and make sense of it. It's not clear what is being said.
Is the expression associates defined anywhere? I couldn't find it. But
No. We don't know what it means. They're not tangibly by particulars tied into the conspiracy by any acts or knowledge or anything like that. It's reverse reasoning. You know, because they're in the defence, he wants to put them into the conspiracy, he puts them into the conspiracy. As explained, many of the women recount their own experiences. There are examples in the articles themselves, and a number are also truth witnesses. I'll come to this in a moment. On the face of it, they were doing so because they wanted the truth about the claimant's misconduct to come out. So we say, on the face of it, this is a classic example of a case where it's not possible to infer dishonesty, participation in the conspiracy, from facts which are equally consistent with honesty and good faith. That they are genuine journalistic sources who are taking the step of going to a public interest journalist and telling their story. And indeed doing the same in the witness box at the trial. So we say the claimant would have to plead very strong particulars, showing that all of his 17, who are referred to here, rather than wanting the truth to come out, were lying to the Guardian or are lying in the witness box in combination in order to injure him. And there are simply no sufficient particulars at all in this pleading.
But forgive me, but what you've done at considerable length, and I understand what you're saying, but what you're doing effectively is you're responding to an application which hasn't yet been made.
Well,
Mr. Williams hasn't opened any of this to us because that wasn't what the judge allowed to happen. And all of this I quite understand, and in some ways it demonstrates why this probably could have been done quite quickly with these very interesting submissions as to why this pleading shouldn't be allowed. But why are you doing this on an appeal rather than arguing it out before the judge?
well, partly so that you can see what would be involved on an application to amend if it were now to be.
Well, sounds like it'd be pretty short and sweet from what you said. You'd go through the pleading and show why it is hopeless.
Well, I'm afraid we're not sure that would be the case, with respect, given the claim.
But what are we engaged in then now?
And to show that the claimant's approach could have been, I'm going to come on to this, could have been achieved much more straightforwardly by amending the existing pleadings in the case against the Guardian.
Well, again, that's something no doubt you would argue in response to their application.
It certainly is something we would argue in response to the application, but it was also something that the judge would have been well aware of as the trial judge having read the pleadings and the document.
She hasn't determined any of this, nor could she, because none of it was open.
Well, there it is. I thought it was appropriate to take you through the pleadings so that you could see what the lie of the land was in relation to the current pleadings and the proposed amended pleadings, to get an idea of how contentious and complicated the amendment application would be if it came to pass. And indeed the possibility that one may end up with the judge saying, well, can you improve this pleading? You know, can you go away and improve
That
it?
certainly wouldn't be a basis to adjourn the trial, would it? The trial would have to proceed if all the judge could say is, well, this isn't good enough, it would have to be amended.
Yes. That's
So
true.
why couldn't you have had that argument?
Well, I'm coming on to that now.
Why couldn't you have it now? I mean, you could go before the judge tomorrow and do exactly what you've done for us, before us, and say, this is a hopeless pleading. Shouldn't possibly be the basis for amendment, let alone introducing these new defendants.
Yes. So if it comes to pass that the outcome of this appeal is there is an urgent application to hear the amendment application, we certainly will argue that. And the court now understands that. But the position of the judge was that, which I'll now come on to, was that the imperative of not risking the loss of the trial through a very late amendment application being heard and possibly succeeding was the most important consideration given the state of play in relation to the trial. So I'll turn to the position that the judge faced and deal with that shortly. As you know, this was a 6-week trial, with the trial listed in 6 weeks' time. 16 of the 28 served truth witnesses were women who would give evidence from the witness box, making these allegations that they experienced sexual misconduct in various forms, including sexual assaults at the hands of the claimant. The allegations in the 23 cases, as the judge was aware, date back, the earliest one to 2004, 2005, and run through the following years up to publication of the article. Any outcome of the case management issues that put off their evidence for another year or more as an adjournment of the trial to add new defendants would have inevitably done, with disclosure and witness statements being required. Risked some of them not giving evidence. That's the conclusion she reached at paragraph 18, at the end of 18 in her judgment at page 49. Perhaps we could turn to core bundle page 49, where we get the key paragraphs in the judgment. The claimant had indicated as long ago as September 2024 an intention to run an unlawful means conspiracy case of this sort. If you can take up the revised supplementary case management bundle and go to page 110, you will see a letter of the 24th of September 2024. And on the second page at 111, paragraphs 3 and 4 on that page contain the indication from the claimant's solicitors that he had strong grounds at that stage to allege an unlawful means conspiracy to spread lies about him involving 5 people. And they included, if you flick back to the previous page, 3 of the current proposed defendants. Penultimate paragraph on 110, Mr. Krishna Floyd, Ms. El Hassani, and Gina Powell. And moreover, if you go back to 111, 4th paragraph, the counsel had been instructed to plead that case as a freestanding unlawful means conspiracy case. These pleadings never materialised. That claim was never initiated in September. The claimant put forward an excuse, and the judge was aware of that. It's referred to in her judgment, and that is the reference to many months ago, I think, that the application should have been made. The claimant's excuse for not seeking to plead the alternative, which he now pursues, which is the unlawful means conspiracy case by way of amendment of the libel claim, was that, as you know, he needed to see our disclosure. This was the case he put forward before the judge. But as you know, standard disclosure was provided on the 3rd of October. The claimant tried to say he was entitled to delay drafting the re-amended particulars of claim until some further small tranches of documents were disclosed by the defendant in October to December. But the judge accepted our case that 99% of the disclosure had been given on the 3rd of October. That's paragraph 16 in the judgment, page 49. Should the figures be relevant, the evidence before the judge at the PTR was that the defendant had disclosed around 4,500 documents in October, and that the further tranches constituted 237 documents. She's right in that, and that hasn't been challenged. Nor has the claimant said why the 4,500 pages provided on the 3rd of October were not sufficient to start pleading the amended pleading in the autumn. Why it was left until December. As we know, no application to amend was made until the 8th of January. And I do say, in the supplementary skeleton, the claimant says, by way of an aside, this is at paragraph 14b, that the disclosure provided in November, December was critical. And that's something a learned friend has said this morning. But it simply was not. The 237 documents added little or nothing to the disclosure. But more importantly, putting aside that perhaps arid dispute, the onus is on the claimant, isn't it? If he argues this, to say why those 237 documents were critical to this ethical obligation to plead the case properly, and say why he couldn't plead it before, but suddenly could when he got those further documents. There's nothing like that before the judge, and there's nothing like that before this court today. The judge was also aware that on the 5th of December, the exchange of witness statements took place. The claimant has said that he was entitled to wait and see whether anything said in our witness statements supported his unlawful means conspiracy case before applying to amend. This is again repeated here before this court. Of course, this was unlikely in the extreme. And before the judge, we said that, and with the trial looming, we certainly didn't accept he was entitled to wait for another month before making the application. The defendant's witness statements, when served on the 5th of December, certainly contained no such material. These would have taken at most a day to read in order to see this, the relevant ones being obviously the 6 G&M witnesses on section 4, explaining how they did the investigation and decided to publish the articles, containing nothing at all that would assist them on a conspiracy allegation. And possibly the Powell and Lucy statements in the truth defence. Again, nothing to suggest that they were conspirators. Yet still no application was made until the 8th of January. No explanation worth its salt has been provided for this further delay of 1 month. So the judge was well aware this was a very late application with no proper justification.
But these are all very good reasons to refuse the application, aren't they?
Yes, and that's why we say on the Court of Appeals test, she wasn't plainly wrong. She was in fact completely right to reject it.
To not hear it?
To not hear it, yes. Yes.
But the points you're making all seem to me to show that there would have been a very strong, straightforward answer to this application, which would have been deployed as you've done it. You've deployed it extremely powerfully in 40 minutes. Why couldn't you have deployed it in longer than that, the week after? I just don't understand at the moment why this extremely powerful case you're mounting as to why the application should have been refused is a justification for why it shouldn't be heard.
Well, I'm looking at the judge's position and the position as it was before her, which of course one obviously has to do on the appeal to the Court of Appeal where there's a challenge of this sort. There are some further points. The claimant served the draft pleading on the other party. The claimant was adamant that it couldn't go on as an application just against us. So he didn't say, I want to amend the existing pleading to make D1 a conspirator, but not add any defendants, just have a conspiracy argument in the existing libel trial. Absolutely adamant, that was the application. Never a suggestion of any alternative form of application. He wanted to add the other defendants. He served the draft pleading on them on the 15th of January, as we know. He did not serve an application to join them on the 15th of January. He didn't serve the evidence in support of an application to join them. And he still has not served any evidence on them in support of an application to join them. And indeed, he's appealed to this court on the basis that he's entitled not to do any of that stuff. That's ground 2. So they're left hanging, as it were, at the moment. And there's this tension between his adamant desire to run an application where they're to be added, but them never being put in a position where they can deal with that application. And it's true the judge said there was a possibility of a hearing, one, to accommodate that problem that the claimant himself created by directions. There was a possibility of a hearing 1 week before the trial or something like that. But with respect, that was not certain, and we're entitled to assume the judge had that in mind. I mean, there would have to be evidence from them, there would have to be evidence in reply, they'd made clear they were going to oppose any application like that. There would have to be skeletons. It's a complicated pleading and a complicated set of facts that they would have to address. Maybe even that suggestion that it could have been got on the week before the trial was unrealistic. But she certainly didn't want, and this is clear from her reasoning, she didn't want to risk in this uncertain future that the claimants had created by their application, it either not getting on in time or it succeeding, either of which might have led to the loss of the trial date. It was made very clear by her in her judgment that that was the scenario she was trying to avoid.
But if the application could have been tried before the trial date and had succeeded, then an adjournment of the trial would be inevitable, but also proper.
No, with respect, that wasn't the judge's reasoning, and we would agree with her about that. I'm going to come on and explain why it would be appropriate to try the 2 existing defences in those circumstances. But her reasoning was clear that the solution to the problem was to try those 2 defences, and then we get to the issue of whether that was unfair and prejudicial to the claimant. But it's a solution, we say, that's plainly rational, within the wide ambit of discretion given on a case.
But if contrary to your submissions, as you've taken us through today, the claimant was right that it was the defendant's delay in disclosure which prevented them pleading this sooner, and if they're right that the disclosure revealed an egregious conspiracy between these persons and agents of Guardian, and all those matters were properly pleaded in the amendment, and that was all brought sufficiently timorously, all contrary to what you've taken us through today, but not decided by the judge. If all that was right, then surely it would then be right for all these issues to be tried together in one trial.
No, what it's worth, we would say not, but the judge's view that we're concerned about.
Yes.
The judge's view clearly was that that wasn't necessarily the case, and that therefore to do it the way she identified could be justified. That I'm just going to come on to now.
Well, that would mean that even if the application was successful, you wouldn't necessarily adjourn the trial then. You could carry on and try the existing issues.
Yes.
So if that was right, the timing wouldn't be a problem then, would it?
But that would be a case management. So you'd then have amended the pleading to have the full case pleaded, and that would be a different case management decision. It would be a case management decision about how to split the trial and what to try first, given that the libel trial involving the one defendant and all these witnesses had been prepared and was ready to go. And therefore the imperative was to avoid losing that. So would a pragmatic solution to the problem be to try those issues and have that evidence and have decisions of the court on that basis? In the difficult position the court would then, on the Lord Justice Phillips' hypothesis, would then face. It would be a difficult position, but I was going to go on and say why that could be perfectly justifiable given the law of libel and the issues in the libel case. So I won't weary you with the law on what has to be shown to say she was wrong. The court's very familiar with that. Obviously, we say these are properly reasoned paragraphs 18 and 19 with no error of principle and certainly not plainly wrong. The argument against that is that as a matter of principle, the claimant is unfairly prejudiced and would in that situation, even assuming the amendment, be unfairly prejudiced by a split trial and trying the first half of the amended pleading, libel pleading, in an early trial, in the trial that had been prepared and listed so as not to lose it. So I'll address that. It's obviously not enough just to say that it's unfair to determine liability in the defamation claim first, because there's some sort of inextricable nexus between the defamation and conspiracy claims. There has to be some analysis. You have to look at the issues in the libel case and the unlawful means conspiracy case that the claimant puts forward or would put forward in order to see whether there is a nexus, and if so, what the nexus is, and then see if it means there would be some unfairness in proceeding in that way. When you analyse the position, there is clearly not an inextricable nexus, a connection that cannot be separated. The libel case separates or untangles itself if either of the defences succeed. So taking them in turn, truth, if the allegations are found to be true, the whole premise of the conspiracy claim falls away. This, as I've said, is that the claimant suffered harm because his true reputation was damaged by the published allegations. If he can't claim to have been damaged, he can't claim to have been damaged in libel, and therefore in unlawful means conspiracy, by asserting a false reputation as someone who did not conduct himself as alleged. That's axiomatic in libel law, and the same would be true in the unlawful means conspiracy claim. If Mr. Lewis, and so that's the truth defence, if the guardian of Mr. Lewis acted in good faith in publishing the allegations, in their belief they were true, and it was in the public interest to publish them, which is their evidence, they were lawfully published. That's the effect of Section 4 of the Defamation Act. So there were no unlawful means causing harm. That's the end of the unlawful means conspiracy. And those are the very issues the judge wanted to be tried in the libel action. Turning to the fairness point, there's nothing unfair to the claimant in trying those defences on analysis on which the onus of proof is on the defendant in the libel trial, provided he has a fair opportunity to answer them and challenge the defendant's case. As far as answering the truth defence is concerned, he obviously does have a fair opportunity, primarily because he's going to give evidence in support of the case the misconduct didn't occur. And when, for example, our 16 truth witnesses allege that it did occur individually in relation to each of them, and that the claimant sexually assaulted or harassed them, he can challenge their evidence to the court as being untrue in the usual way. Indeed, he has to. There's no other choice. This would amount to an allegation that they've lied in evidence to the High Court in 2025. It's different to any allegation in the proposed pleading to the effect that they conspired to relay false allegations to the Guardian in 2021. It's a completely different case. What he needs to put is a case as to why they are doing this. Very different, equally, possibly more serious thing in 2025. Why are they perjuring themselves? We say he doesn't need the whole edifice of the unlawful means conspiracy to do that. If he wants to say to a particular woman, you were a conspirator to lie to the Guardian in 2021, and now what you're doing now, coming to the court in 2025 to give evidence, is sort of more of the same, you're being dishonest again, he can do that. But he would have to put to them whatever evidence he has to support such a challenge to that truth witness. He would have to pick out from the disclosure in the case, or his documents, or whatever documents he has, or evidence he has, evidence that that woman has come along to lie in 2025. And that would be subject to the judge controlling the cross-examination in the usual way. And there's no problem about that. These are pleaded issues. We have engaged on the Section 4 defence and the truth defence between the parties. So he's got to do that. It's just a question of the judge controlling it. He can answer the Section 4 defence fairly. And again, he doesn't need the whole edifice of his pleaded unlawful means conspiracy to do this. What he needs to do is establish that the guardian's witnesses on Section 4 are lying, or either lying when they say they believe the allegations to be true and publish them in good faith, or, as per the alternative in his draft pleading, that they ought to have known that they were false, if that's the case he wants to put. And again, he can put to them individually any evidence he has relevant to their evidence to challenge that witness, and the judge will assess their evidence in the usual way. He says in his skeleton, has always said, I can't put this riposte to the Section 4 defence properly without the full benefit of all the relevant witnesses and documentary evidence. We're not sure who the relevant witnesses are here, but we assume he means the three proposed defendant conspirators, 4, 5 and 6, that we've looked at, who will not be witnesses at the moment. But this is simply not understood. I mean, he could have got witness orders for them, and still could get witness orders for them, without them being parties at the trial, to attend the trial and have that case put to them. They would be hostile witnesses, but he could witness summons them and put that case to them if he's got any evidence. So the fact they're not parties, if there's no amendment, isn't a problem. He can witness summons. He says he wouldn't have all the documents of this trial. But again, this is not understood. His whole case is the basis on which I've been able to amend the pleading is the other side's disclosure and my disclosure put together. And I've been able to dive into that and come up with a case. All those documents can and will be in the bundle at the libel trial. So he can put anything that he says supports conspiracy allegation to the witnesses out of those documents. So there's no shortfall of documents or witnesses. At any rate, it's our fault, or it's anything other than his fault.
Mr. Miller, we are going to have to stop submissions at
Yes.
1 o'clock. I know you started a little bit late, but Mr. Williams is entitled to a little time to reply.
Yes, I'm sorry. I was offered an hour. And
Yes, well, you've had an hour, I think.
have I had an hour?
I think so, pretty much.
My Lords, if it assists my response, it's probably going to be about 4 minutes.
Right, well, you've got another 3 minutes then, Mr. Miller.
Well, my Lord, you've got the point. On both of these issues, he can close his case in light of the evidence, such as it was, that he was able to put to the witnesses. Anyone who's called as a witness or summoned as a witness. There's nothing unfair there. The only potential unfairness is at the end of the case, assuming no amendment, we will have never had a pleaded case to respond to. And we will have to deal in closing with the case he put to the witnesses in cross-examination. And the judge accepted all of that. It's worth noting that the claimant could have applied instead in the autumn to amend his amended reply. Or even at Christmas, New Year, without, and I've made this point, without seeking the whole problem, to create the whole problem of adding new parties. He could have amended it to rebut the truth defence and the Section 4 defence, just against the Guardian, as D1, by putting the substance of his complaint that they fell prey to a conspiracy and published false allegations.
Do I understand your client's position is that they do not object to that unpleaded case being put in the fashion that you've just described?
Provided it's managed by the judge, and provided when we get to closing, we get a clear idea of what he's going to put in closing on the basis of the evidence as it's come out. But he didn't do that either. That would have been a much more straightforward way of dealing with this that would have avoided all of these problems. We don't see any problem in relation to res judicata, because, or indeed there having to be more trials, because once the outcome of the first trial is known, it will either resolve everything And if it doesn't resolve everything, there will be the possibility of the non-D1 defendants being sued.
Well, it won't resolve anything so far as they're concerned. So if the claimant is successful in defeating the defence of
Well, it may resolve
truth, that will have no effect at all in relation to issue estoppel or res judicata.
Well, it
In
may,
relation to the claim against the other defendants, will it?
I apologise, I didn't mean to interrupt.
Yeah.
It may be for Mr. Lewis. There would be the question of whether he's a proxy of the Guardian, so he may well be covered by res judicata. So it may
Leave that on one side. D3 to D7, not.
Yeah. It may end up as an argument against the rest of them, and then you would be into the MBR issues. Is it proportionate and necessary to have an amendment, to have another 2-3 week trial in circumstances where, on the hypothesis the Guardian has lost, it's good for all the damages. The damages are exactly the same in the unlawful means conspiracy involving the 7 as they are in the case against the Guardian. Not one of those cases where the Guardian wouldn't be good for the damages. Would it be proportionate? Would an amendment be appropriate in those circumstances? Just to have an opportunity for the claimant to try out his theory that there were conspirators amongst the others. Answer no, because he'd have got his remedy through the defence's failing. So there'd be no point in it.
Thank you.
Unless I can assist you further, those are our submissions.
Thank you.
I'll try and keep to 3 minutes, my lord. My lord, picking up on Lord Justice Phillips' point, my lord, my learned friend has gone through the pleadings and the amendments, and to coin Lord Justice Phillips' phrase, mounted a strong case. My lord, we have answers to each and every one of those points, and this was what we were actually looking for. I don't need to labour that point. My lord, Mr. Jeremy can, if you need it, I doubt you will, address the points where Mr. Miller is wrong in relation to the pleaded issues and the non-reference to the schedules. But my lord, can I just quickly deal with an important point? There's criticism made of us. Sorry, forgive me. Can you just open that again, please? In relation to the delay point, I just need to knock that out, if I may, quickly. In fact, it's unfortunate that Mr. Miller makes those references today to the delay, because Mr. Miller's own skeleton argument before Master Thornett, final paragraph, the court at this hearing has to proceed on the basis that this trial should go ahead on the current pleadings and according to the current timetable. This is dated the 26th of November. Mr. Miller says, if the claimant is to apply to amend, then the court will be assisted by seeing the trial witness statements. This is a good reason to ensure exchange takes place promptly. So we were encouraged by the defendants not to amend the pleadings until we saw the witness statements. My lord, it is not right to say, oh, we did the application on the 8th of January. That's false. The full re-amended particulars of claim were served on the 23rd of December in the normal way. We said 2 weeks, please. Will you agree? They waited, said no. After the last day, we had to make the application. We did so promptly. My lords, just quickly again, my learned friend has also made great play of the judgment, which I touched upon before. Can I ask you, please, I don't know if you want to read it yourselves, but it's a very powerful position which we put forward to the learned judge as she was misled. May I ask you, please, to look at the further supplemental bundle at page 78. Your Lordship, sorry, forgive me, 75, I'm sorry. 75, the further supplemental bundle. It should be a letter dated the 17th of February.
Yes.
This goes through a number of points, but I'll let your Lordships decipher that yourselves. If you look at page 75, please, you'll see at the bottom, the penultimate paragraph at the bottom, whilst this was challenged by the claimant in the application here, Mr. Justice Steyn held that the defendant could not have contemplated litigation of the publication, deletion. I'll pause there just for a few seconds. There was deletion. There's no issue between the parties on that. There was substantial deletion. And what we say is this is where the judge has been misled. Concerning the course in the reviewing the defendant's disclosure and preparing for trial, we got to the recording. If you turn over, my lords, and this is worrying, the central paragraph towards the top hole punch, following the discussion with Miss Powell, Miss Osborne does not turn off the recorder and continues to discuss the investigation with a third party. In the recording at 33 minutes 30 seconds, this was not before her ladyship, she states he probably is going to sue us, which that, if he does, there is a chance he won't, which obviously would be ideal, but if he does, the next 4 years of my life will be caught up in litigation with that. And it would be lots of work in addition to my other work. And then Paul Lewis, said you're going to have to take time off from the film, but my contract won't allow that, like I have to be full-time on the film. Miss Osborne, sorry, jumping a page, Miss Osborne also states in the recording, that suing thing, you get everything scrutinised. Your private communication, so many conversations with women, there are 24 women we spoke to, I'm sure I said something that was a leading question at some point. She concludes, at this point, I'm really likely wishing I hadn't done it. My lords, I'm not going to trouble you further, but if you read the rest of the letter, it's quite powerful. And my lord, this is what we say, that to actually, for her ladyship to come to the conclusion she did, we say it's challengeable, we say it's unarguable, that her ladyship was misled. In fact, that they did delete messages in contemplation of litigation. But I leave that with you, your lordships. In relation to...
I think we can safely say that's one issue we're not going to decide.
I'm sorry?
I think we can safely say that's one issue we're not going to decide.
They're making the powerful argument in relation to the strikeout judgment. That's the only reason I put that before your lordships. Yep. My learned friend's wrong in relation to the res judicata. The argument is presented, wish we'd had. That's precisely the point. Lord, I have other things to say about delay, but it's just simply not right unless you want me to go through that. They are my submissions in reply.
Thank you.
I apologise for bobbing up. I didn't get the chance to address you on how the court might exercise its 1520 powers if the appeal succeeds. I wasn't proposing to do so now, obviously, but the court has in mind our imperative is to avoid the loss of the trial date. So if a possibility were to give a judgment, remit this matter to the trial judge to consider urgently trying to resolve the amendment application in the hope of avoiding losing the trial date, that would be our preference.
Understood. Thank you. All right. What we propose to do is to rise briefly now to have a discussion. If the parties could stay in court, we'll let you know as soon as maybe what happens next.
All rise. All rise.
What we propose to do is this. We're going to reserve judgment. We expect that we'll be able to hand it down tomorrow. Don't give a 100% promise, but that's what we hope to be in a position to do. When it's handed down, it will be handed down remotely, no need for attendance. It will be a public judgment rather than just a draft, but subject to editorial corrections, so please can we have those, pick up any typos if they may be, but it will be a public judgment handed down. When that has happened, if you could draw up an agreed order. If you can't agree, then put your disputed contentions in writing and we'll deal with them on paper. Thank you all very much.